as much when the tort is directed at a carrier. But that essentially gives away the game, because it's the same tort whether it's directed at a carrier or a broker, and it is no less with respect to motor vehicles when it's directed against a broker who may well know that the vehicles are poorly maintained or the carrier is underinsured or not registered with the federal government at all. Nonetheless, my friends would immunize the brokers in all those situations. That cannot be squared with the plain text or with common sense. Indeed, my friends have to insert words into the statute, like direct linked or direct connection, that are absent from the statutory text. This Court should interpret the statute as written and not let the brokers off scot-free. I welcome the Court's questions.
Mr. Clement, what did the landscape look like before deregulations? And by that I mean, who was responsible for the safety regulations? Was it the ICC or some other federal agency, or was it the state?
So it was both the Federal Transportation Department or subparts of the Federal Transportation Department at the federal level and the states at the state level. So the old ICC regulated rates, prices, and routes, but it did not regulate safety. And that's really the regime I think Congress—
Well, I'm more interested in the safety aspect, because I think much of what we're talking about will depend on what it means to regulate the safety of motor vehicles, including the operation. So I'm interested if you would detail the safety regime before the ICC was deregulated.
So before the ICC was deregulated—
Was eliminated, I'm sorry.
Yeah, eliminated, right. You did have some federal safety regulation from the federal government, but not through the ICC, through the Transportation Department. But you also had, and there was no preemption of it, you also had state safety regulation. And they could take many forms. They could be positive law regulations that go to safety, everything from speed limits to other provisions, weight limits, maintenance requirements. But you also had these state negligent hiring torts that were applied under the old regime, both against carriers and against brokers. And we cite the L.B. Foster case, for example, from the Ninth Circuit in 1969 in our brief. And that's a state negligent hiring claim that was brought against both brokers and against carriers, and the Ninth Circuit upheld it. And, of course, there would have been no basis before 1995 to even argue that claim against a broker was preempted, and no argument before 1994 that claim was preempted against a carrier.